That being said, I'm going to let Angela Davis, attorney. She's a partner and founder of Davis and Gerard and Davis, and she is, as you know, she is part of the ACCG HR helpline. So without further ado, here you go, Angela.
Thank you, Dan, and good afternoon, everyone. I can't see what he sees, so I hate that because I can't see your hands, but he'll let me know if you have a question, and please feel free. My goal today, we're going to spend the next 45 minutes to an hour talking about FMLA. And my hope is that we will walk through, just as I say in my title, A to Z, beginning to end, what would happen when an employee comes in and makes a request for leave, and how you process that through in terms of not only the procedures, but also some of the substantive issues that may come up as you deal with that employee. So I hope that you will learn some new things today, but I also hope to give you confidence in what you already know, because I do, as Dan mentioned, I do the ACCG helpline. If you're a city, I think you have that option on the GMA side. It's not with me, so I'm sorry, but you have that same opportunity. So the calls that I get very often, you know the right thing to do, and you're just maybe not confident, because when you're dealing with health and medical issues, it makes me nervous. It makes us all nervous because there's so many landmines to step in with potential liability, with HIPAA. And so I hope today also as a goal is that you'll reach some confidence in what you're already doing and feel good about doing things the right way. And I'll affirm that for you. And then a third goal I have today is just if you don't remember everything or don't remember anything we talk about today, that you'll just have a sensitivity created to these issues, so that you'll just have that gut feeling that maybe something's not right, you need to look at it a little further. That's what I get in terms of a lot of calls, is someone just feels like something's just not quite right. Just something to lead you to have that sixth sense, to look into it further, to call your county attorney or city attorney, or to reach out to the helpline. So with that all as a background, let's just jump right in, and I'm going to introduce you to, my clicker's not working.
It will. I'm
okay.
I'm playing with things now, so go ahead and try it now.
Oh, there we are. Okay, this is FMLA Frank. He looks like a happy guy, huh? So Frank is who we're going to walk through the process with, and as we go throughout the day, we are going to see Frank making various requests of us and talk about how we handle the request made by FMLA Frank, who may be all of your worst nightmares, because I know some of you have had those nightmares. The first thing I want to show you is this roadmap, and it may not be very big for you to see on the screen. I'm sure it's a little difficult to view at this point, but when you get the materials, this is something I would say print out, just stick it in your top desk drawer, because it's just a nice little truly roadmap to help you from the beginning to the end of the process, just to make sure you're not going to forget something, you're not going to miss a turn. And for those of you who have had those nightmare kind of processes with FMLA, you may not think of it as roadmap, but you may think of it as the highway to you know where. But hopefully after today, you won't feel negative about this process, but you will feel enlightened and confident in it. But each of these stops along the way, through the roadmap of processing an FMLA request, we are going to cover that today. The first thing I want to talk about is backing up one step. So before the employee even comes in to talk to you, you've got to know who you are and what your obligations are. So the first thing I want to mention is covered employers under the FMLA. So my first question, fact or fiction, and I do wish we were sitting in a room together and I could see your hands, but maybe I'll ask Dan to let me know. Here's my statement, and I want you to tell me if you think it's a fact or a fiction. Public agencies are covered employers under the law, no matter how many employees they employ. Raise your hand if you think that's a fact. Can we see that in real time, Dan?
Yeah, and I don't see a lot of hands coming up. So either people are shy, or they don't want to commit themselves.
Or we have technical difficulties.
Somebody says fact here. Okay. I got a lot of hands on the bottom, but that's it.
Okay, fact or fiction?
Here comes a lot of hands.
Okay, are we lots of fact? Okay, and my clicker. I guess when you go to the hands, my clicker
when I click on off of there. Go ahead.
Okay, so it is a fact. So if you raised your hand, you're right on the money. If you're a public agency, and everyone here on this line today is a public agency of some sort, you are indeed a covered employer under the law, no matter how many employees you may have. And the reason I mention this is because you've no doubt heard the concept of 50 employees being coverage under the FMLA. So I wanted to raise that with you. As a public employer, you are a covered employer. But, and here's a big but you may have no eligible employees under the FMLA. Now, this is something that's a real brain teaser, and I want you just to hang with me because it could be important for liability and for defending a claim sometime. Eligible employees are defined like this under the law, and you're probably very familiar with this. You have to work for a covered employer, and we've all just determined that everyone here on the call is a covered employer. That employee has to work for the employer at least 12 months of the preceding year before the request. It must have at least 1,250 hours of service during that 12-month period prior to the start of leave. And here's the little tricky part, works at a location where the employer employs at least 50 employees within a 75-mile radius of the work site. So there's that magic number, 50 employees. Now, I've told you already, if you're a public agency, it doesn't matter how many employees you have, you're covered. But there's a distinction between covered and eligible employees. So here's your first fun fact for the day. Hopefully something new for you. In Georgia, employees of elected officials may not be considered employees of the county when determining whether the county has that requisite 50 employees. Again, you're still covered, but eligibility matters because if your employees are not eligible, you don't have to provide the leave, and most importantly, then they can't sue us if you get it wrong. So there's a case here that I cite. There's other cases. I've even won cases on this principal point of law because you have elected officials, if you're in a county primarily, like the clerk's office or the tax commissioner's office. Typically, the sheriff's going to have plenty of employees, but very often a clerk or a tax commissioner may not have 50 employees. In this particular case, it was a clerk of Superior Court who employed only 8 clerks and 2 interns. And the court found that even though the clerk's office was covered because it was a public employer, it had no FMLA eligible employees. So that's splitting hairs, but that's a split that really can matter. It's a huge distinction that I just want you to be mindful of because I've had some nasty little issues coming out of clerk's offices and tax commissioners' offices. And sometimes I can look at it and say, I've got great news, these employees aren't eligible. And if that's the case, then it becomes a lot easier to deal with them.
So just on that, so there's a distinction between a county clerk's office and the rest of the county, so they count it based on the office.
Well, if it's important to know that it has to have a separate legal entity status in the state of Georgia. So sheriff's offices, these constitutionally elected officers like clerk's office and like the tax commissioner's office, the law will say they are separate and distinct legal entities. So that's important. It's not going to be your planning department, or your health department, things that are separate departments. It has to have a complete separate legal identity. So you have to be careful with that, but it's a question I want you to think about asking next time you have one of those issues in one of your other elected officials' offices, because as I said, we've won cases on those points or run off plaintiffs because they weren't eligible in the first place. Okay, here's another fact or fiction question. And we've talked about it, so let's see if you get this. My agency does not have any eligible employees, so I do not have to comply with the FMLA. Fact, if it's a fact, raise your hand if you think that's true. I have no eligible employees, so I don't have to comply with FMLA. All right, let's see. That's fake news, my friends. Even if you have no eligible employees, you still have to comply with the FMLA. So right now, are you saying, oh my God, my head's hurting, I need more coffee, this makes no sense? And it is a little bit complex. So you can be covered, you can have no eligible employees, but you still have to comply. So what does that compliance look like if you don't have eligible employees? Basically, just that you have to provide this general notice. And I've got a question.
Got a couple questions.
Okay.
Separate, even though they all draw paychecks from the same county.
Yes, if it's a separate and distinct legal entity. So again, a clerk's office, a sheriff's office, a tax commissioner's office, typically their HR and their checks are coming and being processed by county finance, but they have a separate and distinct legal analysis under the law. For instance, you can't control their budgets. Many of you probably know that. You may have come across the fact that if they determine they don't want to participate in your employee policies or in your civil service system, they have that independent right to make those choices. So it's just another step along that line of analysis that they are indeed separate and distinct legal entities.
And here's kind of continuation of that. Even if the elected official's office accepts and adopts all county policies, could they be considered not eligible?
I think so. I mean, you want to look at how you've adopted them, but even if they adopt, for instance, even if they opt into civil service, which very often a sheriff opts into civil service, or a clerk or tax commissioner, that does not mean that they lose their independent legal status as a constitutional elective officer. And they'll tell you that pretty quick, because they're not going to give up their budgetary rights and they're not going to give up their autonomy. So I think really that would still mean that you should raise that question as to whether they have no eligible employees, if indeed they have less than 50 employees. So hopefully by these questions, I've taught you something new already.
I think so. Here's another one. Would that include magistrates' courts? So within the city, more than likely.
Probably not with the magistrate court. We would have to look at that in terms of exactly, I've never had that come up with a magistrate court, but we'd have to look at whether they are deemed a separate, distinct legal entity. They don't fall within the constitutional elected officers. So my guess is no, probably not. It's really kind of those big three: tax commissioner, clerk of court, and your sheriff's office. So with that said, if we've got this crazy situation where you're covered, you have no eligible employees, but yes, you do have to comply, that compliance obligation is simply this, and that is to provide this general notice of FMLA rights. This is very easy to do, and I'm sure that you're all probably doing this, but I think it's important just to put it on our checklist. This general notice, and you see on your screen the actual poster that's produced by the Department of Labor. My suggestion to you is get the poster. It's available free and online. You're supposed to post it in a conspicuous location that employees can see, that's big enough that can be read. They're free. I would get them, and I'd post them in a lot of different places. It's just very easy to do. If a significant portion of your workforce does not read or write English, then you need to provide this general notice in a language that they can read and understand. And interestingly, if you violate this one particular requirement, you can be subject to a civil monetary penalty by the Department of Labor. So it's just a really easy thing to comply with. And as you will hear me say throughout the day today, if the Department of Labor provides you with a form or with a poster, just use it, because then you know that you're not going to have any trouble later on if there's any contentions about what's contained in that notice. The second thing, so now if you're covered and you have no eligible employees, really that's all you have to do is make a posting. And the reason for that would be because one day you might be eligible. If you hire that 50th employee, then your employees have been notified that they would then have rights. But if you have the eligible employees, then we're going to go forward with all the other things you have to do. And that is to provide a more personal and specific notice. So you've already got your posters, and I'm sure everybody's doing that. But secondarily, in addition to that posting, when you're a covered employer with eligible employees, you must provide essentially that same notice to the individual employees. It can be done in a couple of ways, either through your employee handbook, or you could distribute a copy to employees when they're hired. And it can be done electronically. So if you have any question about, oh my gosh, I'm not sure it's in my handbook, or I'm not sure that these employees who were hired since this date ever received it, you could do just a mass communication by email if you wished to provide this personal notice. Again, it's simple to do, but it's one of those gotchas that if you don't, you can be subject to penalty. All right, we're back to Frank. So Frank says to you, I'm going to need a couple of weeks off to help my mother after her surgery. So here's a fact or fiction question for you. So Frank said he needed a couple weeks off to see about his mother. He did not say the magic words FMLA or ask for FMLA leave. So I don't need to give him the FMLA paperwork. Is that true or false? I'm sure you got this one. It's false. There's no magic words here. The employees do not have to come into you and ask for FMLA paperwork. The employer must notify the employee of the eligibility to take in FMLA within 5 business days of when they ask for it, but also within 5 business days of when you have the knowledge that their leave is for an FMLA qualifying event. So if an employee just mentions to you in passing, I'm going to be out for a surgery, or I'm going to be out because I'm pregnant, or I'm going to be out because my mother's having a cancer surgery, you as the HR professional needs to designate that, or at least start the process towards designating that as FMLA leave. And the reason it's important to do that is because you want to ensure that those 12 weeks of leave start rolling and running so that you don't have an employee who is consistently out and ends up stacking up a lot of leave time, because that can be really a burden on the organization. Now, Frank, when he says to you that he needs to be out for his mother's surgery, he says, oh yeah, and by the way, I need to be out by Monday, and it's Thursday. Do we have to approve his leave? He's coming in on a Thursday. He's telling you he needs to be out for this surgery on Monday. What do you think? Yes or no? It's a big no. Generally, an employee must give at least 30 days advance notice if it's a foreseeable leave. So if it's a scheduled procedure, they need to tell you ahead of time, and the law says 30 days is reasonable. Now, if an employee does not provide that 30-day advance notice for an absence that's reasonably foreseeable, and it's possible and practical for them to have provided that notice, then we can delay their FMLA leave. So we could say, no, Frank, I'm sorry, but you can't be out on Monday. You can be out 30 days from Monday, which might mean that a procedure has to be rescheduled. Now, I don't think any of us live to try to make those kind of decisions. That's not the goal. But there's times that I've seen this come up when an employee gives a spur of the moment notice, and it is going to be an undue hardship. There's no opportunity for the organization to prepare for that absence. And so at a minimum, while you might not say, oh, sorry, buddy, Frank, you're out for 30 days, you might be able to delay it just so that you can make accommodations for that absence. So I just wanted you to know about your right on that point. Okay, another question for you.
This is a question just from me. So if you're going to answer this within the rest of your presentation, please don't answer it now, hold it off. But how does that work with vacation time? Or are you going to talk about that?
I'm not going to talk about vacation, so I'll answer that. By your question, do you mean if they say, I want to go on vacation on Monday?
So I'm going to go, my mom's having surgery, and I'm going to take vacation.
Right.
But I might, for 3 weeks, I have several months, I'm going to take vacation. So how does that work? Okay,
well, I am going to talk about it a little bit, but I want to answer it here because it's a pertinent time, I think, to do that. What I talk about that in terms of is concurrent leave. And so your policies are really important here, and this is something I am going to address a little bit later, because in my opinion, a good handbook policy will say that you're required to take these leaves concurrently. So if you have vacation time and you have sick time, a policy could state and be enforced that says those have to be taken concurrently with FMLA. So if you know that it's an FMLA qualifying event, we as the employer have an obligation to designate it, and can designate it whether the employee wants to designate it or not. Now, if they have a 30-day time period and we're saying, oh, you can't be gone for 30 days, but otherwise they're complying with our vacation leave policies, that's going to be a little dicey, and I would say I wouldn't push the 30-day waiting period. But I don't think typically I see employers trying to do that or trying to pull that power move by holding people off for 30 days. But I wanted you to know it's an option. But I do think it's important that you would concurrently, if your policies allow for it. If they don't, then you may be hard pressed to force it. But when I say concurrent, what that means is if you're going to be gone for 3 weeks and you have 3 weeks of vacation pay, then yes, I'm going to start counting off 3 weeks of your FMLA time, but you're going to have to use your vacation time during the 3-week period, and then it's going to be paid instead of your otherwise unpaid FMLA leave. Does that answer your question?
Yes.
Okay, next fact or fiction. Failure to timely notify employees of their eligibility status may constitute interference with, restraint, or denial of the exercise of an employee's FMLA rights. That sounds so harsh. So just failure to timely notify, could we really be doing all those bad things? Interference, restraint, and denial. What do you think? Fact or fiction? It's a fact. So it's important, even though some of these procedures seem mundane, And that's what I really want to get across to you today. And at the end of this presentation, as Dan mentioned, we're going to follow up with some forms for you and some checklists so that you can just get your arsenal ready. So when the next person comes at you, you can just fire away with all of these procedures in place. You've got 5 business days, and that's not long. 5 business days once you have the request made of you, or you know that a request is appropriate because you know it's a qualifying FMLA event. There is a DOL form for purposes of providing this, what it's called as the Notice of Eligibility and the Rights and Responsibilities. It's a form that's titled as such. We'll provide those forms to you following this presentation if you don't already have them. But again, my mantra is just don't recreate the wheel. Use the DOL forms. Sometimes, if necessary, I will craft a letter to go with it if there's some unique situation, but otherwise rely on the forms, and it's got blanks to fill in, and it creates a checklist for you. But 5 days, and if you fail to do it in 5 days, then you can have some financial and monetary liability. Now, what does this notice say? You're probably very familiar with this, so I'm not going to spend a ton of time on it. But I will tell you, when I get calls from my clients or from helpline clients about FMLA, the first thing I will say is, can you send me your Notice of Eligibility and Rights and Responsibility document? And sometimes there's a long pause of silence. And that's immediately going to make me nervous because that's the first thing that we have to do as the employer. And the reason it's important is not only to meet that 5-day period, but it starts the documentation on making sure everyone's expectation and understanding of the request and the qualification for the leave and the eligibility for the leave is established. And so the reason as a lawyer I'm going to ask for it first thing is because it's going to be the Bible for me to tell me what has happened, what they've requested, what we as the employer have told them they need to do. So it is an important document. And many, many times I'll see a document like this that's halfway filled out. So take the time. This is really, really an important form. It's going to tell whether the employee is eligible in terms of length of service, hours worked, and number of employees at the work site. It's also going to state what the qualifying condition might be. And we'll talk about that in a little bit further detail. But is it the birth of a child? Is it a serious medical condition? Is it a qualifying exigency with military leave? It's also going to give you the opportunity to check a box to say you're required to provide a medical certification or a certification of the family relationship. So it's an opportunity where not only you're telling them what their rights are and getting their input, but you have the opportunity to check a box and tell them what you're going to require of them. Now, got a question.
So we have a lot of departments spread out, other elected officials. Sometimes we don't know someone is out for a couple of weeks or more. Should we go ahead and send the notice when we find out, even though the employee is past the 5 days?
Yes, I think that's a great question. Yes, I think you do have the duty to designate it when you become aware. You know, some internal training, if you have the opportunity to do that with the different department and directors, because I know that happens. They're not all coming to you, and that makes it very difficult because they're just approving it probably like it's vacation. That kind of goes to Dan's question earlier. So, but absolutely, I think that's intuitive of you to ask that question. If you come to know about it, then absolutely designate it appropriately as leave, because in doing that, it also gives the employees rights. So it's not just that we're trying to catch them up and click a clock, you know, to make sure that they don't get more than 12 weeks off, but it also entitles them to rights that they have under FMLA to be restored to their job, to have a continuation of their benefits and so forth. So it's good for both sides to ensure that this leave gets designated appropriately. And typically employees are very cooperative with that. They simply just don't know. Their managers didn't know. And so that's where you come in to ride in on the white horse and fix this after it's not been done within the 5 days.
2 more questions.
Got it.
What do you do if an employee is going to be out for a while but does not want to fill out FMLA forms?
Well, that's a good question, and it happens more times than not, where either the employee does not want to fill them out or the employee is just delaying in filling them out. If they refuse to fill out the forms, then obviously you can't grant the leave and it could be denied. However, if they're just out already, which is typically the case, they're just out, whether either they have vacation they're taking or sick leave they're taking, or they're just not showing up to work. I've had those situations and those calls many times, and I think there's a variety of things you need to look at. One, I think you need to look at whether they have constituted an abandonment of their position. That's a little bit beyond what we're talking about here today, but sometimes that's the case. You know, if they don't have the leave or they haven't followed the leave requirements appropriately, your policies may say they're deemed to abandon the position, and then they could be separated. Otherwise, if they're out and on vacation, so they're on an approved leave, and you know that it needs to be a qualified FMLA leave and they won't fill out the paperwork, you really need their input, because you need to know what the situation is if you don't know all the details about the leave. But if they don't, again, I would fill out the paperwork, I would designate it as leave or deny it and deem them to be out inappropriately and without authorization, and that again could be a separable offense if your policies so provide. So there's a lot of things going on with that question. I hope that kind of gives you some ideas about how to approach it, but that's when I'd want to drill down with you to talk about really what your policies say and what the employee is doing. And a lot of these questions are super fact sensitive, because your policies really dictate a lot of how things may be handled. And also, if that employee is out and may have a disability, then you know that we start creeping into ADA. So take that with a grain of salt, but that's one where I would say likely you want to go ahead and designate it, but you also might consider whether there's a separation event based upon abandonment or failure to follow policy.
Last question: should constitutional officers and elected officials provide this to employees since their employees are not eligible for FMLA?
Provide notice. Or provide what?
I'm not sure.
Okay.
Tracy, if you hear this, can you specify what that would be?
She may be meaning notice if you are able to get an answer. So if you remember, we talked about the fact that you could be covered with no eligible employees, but you still at least have the base obligation to provide that general notice. So you would need to do that. But beyond that, if you have an employee who's within a constitutional officer's office that does not have the requisite eligible employees, then the answer would really be no, you don't have to designate it as leave because they're not eligible for that leave. And it'd be fine if you feel like if they're asking you about it, then you can explain why they're not. And that's part of the eligibility notice. I mean, the eligibility notice has blanks where you check why they're not eligible. And so you may still want to provide that notice form, and you could, to show that they're not eligible. And I think that's a pretty good practice to document it if they're coming and asking you. If they're not coming and asking you, and if the question is, do I try to designate it even if they haven't come to me, then in that instance, I'm not sure that you really need to undertake that obligation. Maybe they're not asking because they know they're not eligible. I hope that answered that question. On qualifying leave, you know, there's these 5 main things. There's birth, there's adoption and foster care, time to bond with the baby, there's serious medical condition of the employee, serious medical condition of a spouse, son, daughter, or parent. And then the qualifying exigent circumstances arising out of a military member's covered active duty. The general rule is 12 weeks of FMLA for any of those qualifying reasonings. And again, that eligibility notice is the opportunity where the employee will check what basis that they are seeking to be out on leave for. All right, so here's a question for you. Leave for spouses. And I'm always amazed how many relatives are in so many of my client counties and cities. Seems like there's a family tree in most of the governments. And so very often you may have a husband and wife that work for the same employer. If that's the case, and here it is with Frank, his wife Francine, they work for the same employer, and Francine has a baby. Frank wants to take off 12 weeks to bond with the baby after Francine has already had 12 weeks to have her time with the baby. So I've got a 2-part question here. Do men get FMLA for the birth of a baby? And would we have to approve Frank's 12 weeks in addition to Francine's 12 weeks? And the answer there is a yes and a no. The right to FMLA leave for the birth or placement of an adopted child applies equally to men and women. So Frank would be entitled to leave based on the bonding with the child. However, when spouses work for the same employer, the law says that you can require combined leave under certain circumstances, including the birth and bonding of a baby. So that would mean they don't get 12 plus 12. They would have to share their 12 weeks for purposes of this bonding time with the child. There are some other circumstances as well where combined leaves are required. Now, obviously, you can give more than the law requires, and I've seen some governments want to do that. However, just know that if you have spouses that work for the same employer, know that you have some leeway to determine whether combined leave is appropriate under the law or not. And in this case, it is a yes and a no. Okay, got a question?
This is my question personally, and it really goes to policy. So you're talking about policy, having a strong policy. So if people are making exceptions to policies, that's setting a new standard. But if you make an exception to policies based on workload or available, so if, let's say that within your county or your city, one department is fully staffed and that person can take off, and then in another department, they don't have the amount of resources to be able to maintain it, so you're not able to. Can you make those exceptions based on staffing, or does it you have to be consistent in regards to everything?
It's a good question, and I feel like you know the answer to that question, but it's a good one. No, I would not make any exceptions to policy. And so when I say you can give more, I would want that to be written into your policy and applied uniformly. And that's true. There's times where one department can lose a person, and there's another one that's short-staffed, or they drive vehicles and every vehicle has to be manned, and they just can't do without someone. So I know sometimes there are different circumstances, but as soon as you try to make those exceptions and engage in those weighing of the different things, someone's going to argue they're being discriminated against. And FMLA, an application of FMLA to different parties can indeed be a discrimination claim if it's not handled in a consistent and uniform manner. So if you intend to allow any special spousal leave, then it needs to be in your employee handbook, and it needs to be available for all employees that are spouses within your employment. I had a client recently who actually wanted to offer something even more. They were calling it Family Leave Act, and this has not taken on a huge amount of traction, but I'm seeing it in a few counties now. And Family Leave Act, there's nothing under the law that requires it, but just giving an extra opportunity where the person who's out having the baby could get paid 60% of salary while they're out for their 12 weeks. Ultimately, I've had counties say we can't afford to do that, as good as it sounds. Others have been concerned about, why do we benefit pregnancy leaves versus a cancer leave with pay? But I just wanted to mention that's just another example of you can do more in certain areas. If you do, I would want to let's analyze it closely on a discrimination basis, but it always needs to be written into your policy because, as Dan mentioned, an exception becomes a new standard. And so you don't want to make exceptions in that manner. Now let's talk just a little bit about, I got one more question.
If using combined FMLA leave of 12 weeks for childbirth or adoption foster, then each parent has the remaining 6 weeks of FMLA leave available for the 12 months. Should be another qualifying, leave available for the 12 months should another qualifying issue come up?
Yes, that's right. That's right.
And here's another question. If one spouse is full-time, this is a math question. If one spouse is full-time and qualifies, but the other spouse is part-time and does not qualify due to the work hours, does FMLA only apply to the full-time spouse? Right, that becomes an eligibility question. So if the spouse does not meet the eligibility requirement in terms of service or either hours of service, then they're not FMLA eligible in any event. So that husband could take the full 12 weeks. So yes. Okay, as to certification, we're back to Frank. Well, he's had his mother, he's had a baby, and now he has his own serious medical condition. All of this hasn't happened in the same year, so we're tracking Frank, of course, across a few years. So I want to tell him, because he looks so happy and vibrant there, I don't believe he has a serious medical condition, so I want a medical certification. So how do you handle that?
Can I require details about his medical condition, or will that violate his right of privacy such that I can't ask for details related to his need for leave? And this is where I think a lot of HR professionals do get a little antsy and nervous, because it does start creeping in to where you feel like you're invading privacy, you're worried about HIPAA, but under FMLA, here's the answer. It's not going to invade their privacy. That's false. You have the right to ask for information and ask for a certification of the serious medical condition. And I think it's important that you do so whenever it's questionable. But here again, it's very important that you apply it uniformly. I was teasing a little bit when I said, you know, because of the way he looks, I'm going to make a decision that he needs to have a certification. Don't do that. You need to make sure you apply it uniformly. If someone tells you they're having a surgery and they show you a doctor's orders for surgery, that's pretty easy to determine it's an FMLA qualifying event. If someone just comes to you and says, I'm not feeling well and I need to be away for 12 weeks, that might be the time, and that there's not some scheduled procedure that you determine that that's your bright line rule for requesting certification if there's not otherwise a doctor's order for a surgical procedure or other doctor's notes that they're bringing to you. Then you can request that they be required to submit that certification. And again, remember, you have the opportunity to do that on the DOL form. That's the eligibility notice form. Now, the employee, if you require them to provide a certification of their serious medical condition, they're required to do it, and they're required to pay for the cost of doing the initial certification. If the employee does not provide the certification, then you as the employer may deny the request for FMLA leave. Here is a little flow chart. Again, may not be very big on the screen, but it might be one worthy of printing out with your roadmap. And this is just certification at a glance. Gives you your options. So if you look at step 1 and you've told the employee that they must provide you a certification of the medical condition. Step 2, the employee has to do that, and they have to do it within 15 calendar days. So you notice everything moves quick in the FMLA road. There's just a high speed limit because you got 5 days to provide them with notice of eligibility. You tell them they need to get a certification, and they've got 15 days to get it back to you, absent unusual circumstances. Step 3 then, if all goes well, would be that you determine whether that leave will or will not be FMLA protected. Does the serious medical condition and the certification you get fit within the FMLA criteria? But usually it's not an easy step 1, step 2, step 3. And that's what we're going to talk about in a little bit more detail, but let's just do a little foreshadowing here on this flow chart. So if you get the certification, you got it within 15 days, but it's not clear, it's not complete, you believe there's deficiencies in the certification. I see this all the time where doctors really write virtually nothing. They may say employee needs to be out of work, employee can't lift, but you don't know how long they need to be out of work. What are their full limitations? Are they going to be intermittent? Are they going to be out full time for how long? So if you believe that the medical certification is deficient and doesn't allow you to make a determination as to how much leave is appropriate under FMLA, then you can ask the employee to get more details from the medical provider, and they have an obligation to do that within 7 days. You also have the opportunity, if you just walk across that flow chart, to ask the employee, but also to contact the health provider directly to clarify or authenticate. And I'm going to talk about that a little bit more. All you can do is ask them to clarify or authenticate. You can't get into details of the employee's medical condition that's not otherwise on the form, but very often you can't read the doctor's handwriting, or you need to authenticate and say, here, I've gotten this from the employee and I want to clarify that this came from your office. We'll talk about that more in just a moment. Another option, though, is you get the medical notification or certification, and maybe it's complete, but maybe it's very questionable to you. If that's the case, you can require a second medical certification, a second opinion, if you will. If you elect to do that, though, the employer has to pay for that. And if the second opinion is different from the employee's first opinion, then the third opinion is required, and that's at the employer's expense as well. And then that third opinion will be the final one that controls. So that's an overview of certifications, and let's walk through it in a little bit more detail. As I've mentioned to you before, I love the DOL forms because when you have a claim, nobody can contend that you did not have an adequate form that you used or that you put something inappropriate in front of a doctor. The FMLA doesn't require specific certification, but you will see here I've listed all these DOL forms that provide certifications that you can hand to the doctor to fill out exactly with all the information you need for each of the varying qualifying conditions. Now, if Frank is required to provide this certification in his notice of eligibility and rights and responsibilities notice, because remember, we've given that to him in 5 days, we check the box, you have to do the certification, and you've deemed it to be incomplete, can you require him to provide more information? And I foreshadowed this just a moment ago on our flow chart. The answer is yes. You give Frank notice, and then Frank has 7 days to provide you with additional information to complete the certification. If he fails to do that, then the FMLA leave can be denied. Intermittent leave is one that drives us all crazy. I know it does because it's hard. It's almost easier sometimes to have an employee who's just out and you make the changes that need to be made in the organization and then you expect them back at a certain time. Intermittent leave, though, seems to be more and more popular, whether it be for treatments or counseling type sessions, because there's a lot of different mental based things that are coming up now as serious mental conditions or medical conditions. Intermittent just means they're not going to be out for 12 weeks, but they may take an hour or two here over the course of a year that builds up to 12 weeks. It's hard to manage. It's hard to calculate, and often it's very hard on the organization because managers don't know when this employee is coming and going. But it is a right that they have, and very often if it's a cancer treatment or some other kind of treatment, kidney dialysis, there are real legitimate reasons that intermittent leave is the appropriate type of leave, and we can't force them to be out full time if they're able to work a portion of the time and only be out intermittently. If you do have an employee asking for intermittent leave, then you can require some more information from the doctor because you need to know the frequency and the duration so that you can build a schedule that makes sense for you and for the employee. Also, and this is something I'm not sure a lot of people are aware of, and I think this is really important, an employee seeking intermittent leave can be transferred to another job with equivalent pay and benefits that better accommodates the recurring periods of leave. So for instance, if you've got a sheriff's officer who is a patrol deputy, but intermittently he needs to be out, in the middle of his 12-hour shift for 2 hours at a time, that's likely not to be easily accommodated because you can't just pull in another deputy and send him out on the road for those 2 hours and to fill that hole. So it may be appropriate to transfer him to the jail. He needs to still get equivalent pay and benefits, but that would accommodate his intermittent leave in a much better way if he's in a desk type job where other people can easily cover and fill in for him. That's just an example, but there may be other examples that you have, maybe your roads and bridges departments. That would be something I can see if you have people that are out in the field, not easily accommodated. There might be a desk or administrative type job. Think of it almost like a light duty type situation. But again, it's important that they not be discriminated against and they not be reduced in pay or benefits. True or false? I can require a doctor's note for each intermittent absence. What do you think? Is that fact or fiction? That is false. After you've gotten a complete certification, you cannot berate an employee to provide you with a doctor's note every time they're out intermittently. And that's another thing that makes it difficult because I've seen situations where just, honestly, people abuse the situation sometimes and they're intermittently needing to be gone and maybe they're not going to a treatment or to a doctor or they don't need that rest period, but they're going to a party or to a vacation. But we cannot require them individually to bring a doctor's note each time. That would be deemed to be an interference with their FMLA leave and would be a liability type situation. Concurrent leaves. This is something that Dan mentioned earlier and I touched upon. This is important for your handbook policies to address this. So it's not something that you can just do on the fly. You need to have a policy so the employee has an expectation. But the employer may require that accrued vacation or sick leave be taken concurrently. You should put it in your employee handbook. And again, if you use the DOL notice for eligibility and rights and responsibilities, there's places to check whether leave must be used concurrently. The employer may also require that disability leaves and workers' compensation leaves run concurrently with FMLA if the underlying condition is a qualifying FMLA condition. So short-term disability, workers' comp, very often all of these things just cross over each other. And if you don't have the ability under policies to require concurrent leave, then you can have a situation where someone's accrued maybe 6 weeks of vacation, and then they get their 12 weeks of FMLA, and maybe they've built up 4 more weeks with sick leave, and then they decide to go out on short-term disability. And then you've got a situation where the employee's gone more than half the year, and yet still with that FMLA leave at the end wants to be restored and have their job held for them. That can obviously really present a hardship on the employer, and that's why the law does allow you to say you can have these leaves, but they all have to be taken at the same time concurrently. And it can be a benefit to the employee because they're getting paid for a portion of their otherwise unpaid FMLA leave. But the big benefit for the employer is it prevents the stacking. So what happens during FMLA leave? The employer must maintain the employee's coverage under any group health plan. And that's one of the biggest benefits for employees as they're out on leave, is that they're going to have the same coverage as they would have had they been continuously employed during the entire leave period. But importantly, the employee must continue to pay whatever share of his premiums that the employee paid prior to FMLA leave. So if it's fully employer funded, that's fine. But if the employee does pay a portion of premiums each month withdrawn from their paycheck or otherwise, then they have to continue paying that. And that sometimes can produce an issue, because if it's usually being a withdrawal from their paycheck, but they have no paycheck, then they have to make arrangements with HR to make those premium payments. Interestingly, the employer can recover from an employee its share of health plan premiums that are paid during the employee's unpaid leave if that employee doesn't come back. So, I mean, we get skeptical, I think, and cynical in this world of HR sometimes in law, but if an employee provides notice of FMLA and has no intention of really ever coming back, but he stays on your group health insurance plan, so you keep contributing and he gets another 12 weeks of health insurance coverage and doesn't come back, that could be an abusive process. So if that's the case, you could recover your share of the premiums for that employee that does not come back to the workforce, unless you see a couple of exceptions there. There is a serious health condition that continues past the expiration of their leave, or if there's some other circumstance beyond the employee's control, usually health-based, or maybe a deployment, or maybe a required move because of another family member situation. And I'm trying to move right along because I usually try to wrap up in 45 minutes to an hour. So I'll keep talking, but please let me know if you have
lots of questions.
Oh, okay.
So you should not feel bad about being there. We can move on. We didn't start until 5 after. So if employee is approved for a certain amount of time designated by the physician, but does not have specify intermittent leave, can we file as intermittent or our own? Also, if they wanted to extend FMLA for the same reason after the return date started or stated, can we approve it without a physician form?
Okay, I'm not sure if I followed all of that. So if a physician has approved leave, say for 4 weeks, if the question is, if the physician did not reference intermittent leave, but now the employee wants it to be intermittent leave, my recommendation there would be to have the employee go back and bring you a medical certification that provides for the exact leave they intend. I say that for a couple reasons, because one, you don't want the employee later to argue that you interfered with their FMLA rights or otherwise discriminated against them by pressuring them to be back in the workplace for some period of time. I've had that come up before, where an employee goes out, but then they realize, well, if I'm not back at work to do this training, I'm going to lose my certification, and then it's going to be an issue with me maintaining my job. And if they wanted to come back, I've wanted them to document, one, with their doctor that it's acceptable for them to come back, and two, that they're asking us for the right to come back, because we don't want it to look as if we've interfered with FMLA by trying to get them back on an intermittent basis. So I would not allow that to be changed up without a doctor's certification that authorized that. And then there was a request about, I think, extending. I think that was the second part of the question. Again, I think, you know, there's times that you are familiar enough with the facts that you can feel comfortable believing that an extension is appropriate. You know that there was, you know, an infection following surgery and things didn't go as well as you expected, and they're not able to come back and they're communicating with you, and all that's fine. I would still say, though, ask for the doctor's certification, because you really, really want to be sure to document all these issues. Because as much as we're always working in good faith with these employees, if something goes wrong and ultimately they never return, or they continue wanting an extension, and we have to ultimately put our foot down and say, now it's an undue hardship, we cannot continue extending, but you don't have any documentation of the leniencies that you've given, you really find yourself in a mess. And I've had that happen more times than I can count, where the employer has bent over backwards, but has done that in a kind way and has not required documentation, and then the record is not clear. And it gets messy at the end when at some point, you know, the straw's broken the camel's back, and you as the employer says, okay, no more, we can't extend anymore. They've had their 12 weeks, we've given them 2 more weeks, and then we gave them 3 more weeks, and now they want 4 more weeks. Or even worse still, and I'll talk about this a little bit right at the end, they have an indefinite leave request because the doctor won't certify when they can be back. There may be a point in time where you have to say no more extensions. And if that's the case, it's very important that each time you've required a doctor's certification, so it doesn't appear that you're trying to discriminate against them in the end if you ultimately ask for one. So just be consistent and require it each time. Anytime something changes on the designation that you provided or the eligibility of notice of rights and responsibilities, anytime something changes, I would say you want to redocument that change. All right, so I mentioned this previously in the flow chart on certification. So if Frank is given the opportunity to provide additional information, we can ask him to do it. We can't just call up the doctor and ask the doctor to do it unless Frank gives us a consent form, just like any other HIPAA consent, and allows us to contact the doctor's office. Sometimes that happens because an employee will say, hey, you go ahead and just call them and make sure you get the information you need, because they just want to expedite the process. But we can't on our own do that. We can authenticate. Dr. Brown, I just want to make sure this is your signature and this came from your office, because I've actually had, you know, situations where it was not actually a doctor's signature. So you're well within your rights to authenticate if there's any reason to believe that it's been forged or is fraudulent, or ask him to clarify. You know, doctor, I can't read what this says right here. Does this say that they can return in March, or does that say May? Those 2 things you can do with your own initiative to the doctor's office. What you can't do is call and say, oh, you know, you say here that Frank, you know, needs this surgery, but what about this? Could he not do this procedure instead? Or how long do you think? I mean, you just can't do that. You can't do that because it gets into HIPAA-based privacy concerns, and I think you would all know that. The other thing that happens sometimes is you've got, you know, Frank working down at the Roads and Bridges Department, and he needs to be out, and he's having trouble getting his medical certification. He's talking to his manager, and the manager says, you know what, let me just call the doctor. I'll call him, I'll get to the bottom of this. Manager can't do that. This all needs to run through HR or the highest level people that are involved with the matter, just like any other HIPAA-based issue. It's not something that should be widely spread, and it should not be something that you're sharing widely with the managers in terms of the qualifying reasons or any of the details for intermittent and otherwise, just simply that here's the leave, here's when they'll return, or here's when they need to be out intermittently, without getting into any of the HIPAA-based concerns with details of their health issues. Second and third opinions, I mentioned this previously. Yes, they're permitted, and sometimes they're necessary. You can deny the employee if they don't cooperate. Third opinion means that it's final, and the employee and the employer have to agree on who that third opinion will come from. Now, this has been a long road where we've given them eligibility rights. We've gone through certification, and all of that is to determine whether they're actually entitled to their FMLA leave. If they are, at the point at which you have the information to make the decision, which would mean in the case of requesting a certification, you've gotten the certification and it's complete, then again, it's that magic 5-day period. You have 5 business days to designate the leave. And the designation notice is also a DOL form that I would recommend, and I'll provide it to you after this presentation, where you just fill in the blanks, and it will inform Frank that the requested leave was approved or was not approved, and would set out the requirements applicable to Frank while he's on leave. So if he needs to pay his premiums, that's where it needs to say it. If he needs to provide you with a recertification within a certain period of time, it'll provide that. That's where you set up the rules for how things will work during this designated leave. And again, to some of your questions about whether the employee has not asked for leave, but you know it should be designated leave, then this is the form you would fill out to designate the leave on behalf of the employee. Recertification is something I don't see come up a lot. You can seek recertification after 30 days. My recommendation is you really don't want to busybody too much in an employee's leave. Once they're out, and if you have a certification that was complete and a legitimate basis for the leave, then you really should just think of them as gone and forgotten and not be contacting them. But you can request certification after 30 days if you believe it's necessary for some reason. Also, under 30 days, you can do it as well if there's an extension of leave requested, if there's something that's changed drastically that you believe a recertification is important, or if you receive some information that casts doubt on the stated reason for the absence. You know, the guy's, you find that he's out skiing and he's supposed to have a broken leg. So those types of things could justify a recertification process. But interestingly, the employer does not have an option for second and third opinions on a recertification. Fitness for duty. I think this is an important way to close the loop on FMLA. You can require fitness for duty certifications from the medical providers before they return back to duty. Again, this is a box that you're going to check when you provide them with the notices that are required by law. If you request this leave and you request that the certification be provided, then it needs to link up to the reason for the leave. So whatever that qualifying medical condition is, then you need a certification for return based upon that condition, not based upon a general fitness for duty. Also, if you've told the employee in the notice, the designation notice, that they're going to be required to provide a fitness for duty that must indicate that they can perform all the essential functions of their position, then you should provide a copy of that essential functions list for the employee so they can take that to their doctor. And again, I do think that's a nice close the loop situation. Very often I've had situations where I get a call and an individual has been out. The employer does not believe they're capable of coming back and either going out on patrol as a law enforcement officer or hopping on that fire truck or driving that tractor to cut the grass, but they finished their leave and they're kind of limping back into work because they don't want to lose their job. And so to the extent particularly it's a position where their inability to perform or not be 100% could expose the county to risk, it's really important that you get this fitness for duty certification before they come back. And it's better if you just tell them on the front end that you're going to do that. Under a fitness for duty process, the employee pays. We can delay restoring them to their position until they provide us that fitness for duty certification. And we can also require an examination separate from their medical certification. We can do our own fitness for duty if the employee comes back and we have reason to believe that maybe the employee is not well enough to be back. But just like any fitness for duty that you might do, you have to be careful under the Americans with Disabilities Act that you can demonstrate that the request is job related and it's consistent with business necessity. But that's your own independent opportunity for fitness for duty. Now let's talk really quickly about what happens when FMLA leave expires. This is probably the question in the call I get more often than any other issue. Frank's been out and Frank's leave expired on May 1st and Frank doesn't show up. So on May 2nd you reach out and then Frank says, you know, I think I'm going to need a couple more weeks. Well, it's appropriate to ask for an additional certification. Maybe the doctor gives you a certification that yes, Frank needs 2 more weeks. So is it reasonable at that point? He's had his leave. That's legally all he's entitled to. Do you agree to give him 2 more weeks? Those are very fact-based decisions. Maybe you agree to that accommodation, but do you agree then when the doctor comes back and says, you know, he's going to need another 4 weeks, he's still not recovered? I've seen these scenarios so many times, and that's why I was mentioning earlier about documenting and requiring a certification at every step of the way, because once they've expired, really that's when FMLA shuts off. But as I noted at the bottom of the slide, you have to be mindful of the Americans with Disabilities Act, because if they're out, say for instance, they have a cancer diagnosis and they've had surgery, they believe they were going to be able to return on May 1st, but they're not well enough to return. Either chemo's continuing, they're too weak to be back, or they need to have another procedure. FMLA leave is expired, but is extended leave an accommodation that's reasonable to the point that it's legally required under the ADA. So that's where FMLA and ADA can cross. So just to be clear, an extension of leave could be deemed a reasonable accommodation under the ADA, such that you need to consider it and provide it. Now remember, with any reasonable accommodation request that you receive under the ADA, one of the requirements you can make in terms of your analysis is whether that accommodation creates an undue hardship on the employer. And if you've got Frank who asked for 2 weeks and then 4 weeks and then 6 weeks and it's continuing on and on, at some point I've comfortably concluded this is becoming an undue hardship of indefinite leave. And in fact, there's case law that says an indefinite leave request is absolutely not a reasonable accommodation. And sometimes you'll get that from the doctors. You'll get a notice where they cannot say unequivocally, Frank is going to be back on May 1st, but they say, we're still seeing Frank, we'll continue to review his progress. He's expected, this is often the case, he's expected back in the office on May 14th, we'll reevaluate at that time. I think I have a question.
An extension of leave would not still be FMLA. Depending on our policy, it would just be unpaid leave for ADA purposes, correct?
Yes, that's how I would absolutely characterize it, because once FMLA shuts off at 12 weeks, that's it and it's done. So that's exactly right. So once you start extending it, you are doing it as an accommodation under the ADA. So really, if you don't believe it's a disability-based situation where an accommodation is necessary, then you really should apply FMLA with an expiration date and apply that strictly. But very often it does cross into where an accommodation may be required under the Americans with Disabilities Act. I would say anytime you have a leave expire, that's the time to pick up the phone and call me if you're a county through the helpline, or contact your county or city attorney, because that can really open up a landmine of potential liability exposure, because requiring an employee back when they may be entitled to an accommodation is a problem. But I know how just the operation of the organization can become very, very difficult if you have an employee with no end in sight. And I know how frustrating that can be. So you want to get a handle on that, I would say, immediately when the leave expires, and not wait until you've gone down the road a ways. And my clicker, let's see.
Let's see. What if we have someone who has exhausted her FMLA and we've sent her a letter telling her she may have other options and to contact us? What happens if she does not respond to us?
That's a great question, and it happens all the time. I would do this. I would continue to document. You know, if this employee is not responding to you and you've sent notice, I would try to send another notice, and I would tell them what's going to happen. So if you've said you may have other options of leave, please contact us. They don't do it, I would send another one, and I'd say, as we wrote to you on February 14th, your leave is expired. There may be other opportunities for leave. We need you to be in touch. If you don't communicate with us by February 28th, at that time, we're going to deem you to have abandoned your job. So I think you want to give them a couple of shots, couple bites at the apple. You need to be clear in your documentation so that they have an expectation of what could happen. And then I do think you can take action on it to separate. You know, be mindful of just the practicalities. If this person is in the hospital in a coma, if this person you know is in rehab and is unable to respond, then take that into account and maybe communicate with a family member if that's possible. But more times than not, and it happens a fair amount, I think the employee goes out, they have some kind of surgery, they do have a serious medical condition, and they just don't intend to come back, but they're not great at communicating that. So it's important to document. All right, farewell, Frank. If he fails to return to work, kind of the scenario you just talked about, or the doctor's notification that provides an indefinite return date, whether there's no communication, so it's just an abandonment situation, you may determine that it constitutes an undue burden under the ADA and the FMLA. You may determine that it's just an abandonment under your employee handbook policies, and ultimately there may be a separation. So please just know that just because an employee is entitled to FMLA does not mean that they have the right to just indefinitely extend or indefinitely fail to communicate with you. And I think sometimes we get nervous about pressing those issues. You want to do it and do it wisely, specifically with respect to consideration of the ADA, but just know that you have an opportunity to ensure that you're enforcing your rights as well. And it may be farewell, Frank. Now, restoration. Let's say everything has gone well. Frank's had his leave. He's provided his fitness for return to duty. Everything checks out fine. Then what is your obligation on restoration? It's pretty simple. The same job, if that's possible, or an equivalent job, if that's not possible. There's no guarantee under the law that the actual job that he or she previously held will be available, and they have to know that on the front end. But an equivalent job means a job that's virtually identical in terms of pay, benefits, and other employment terms like shift and location. So if they were someone that worked the day shift and they were a captain in the sheriff's office and they received XYZ salary, then putting them into a role where they're a deputy on the night shift with a pay cut is not going to be restoration, and that would be a violation of their FMLA rights. They also get the benefit of any pay raises that were applied uniformly. So if there's a COLA that's applied, they get that automatically, even if they were out when that COLA was applied. They would not get necessarily any kind of incentive bonuses or raises or any kind of performance-based raises unless your policies otherwise provide. But they should get anything that's uniformly applied across the board. Our last point I want you to think about is record retention. So records have to be kept a minimum of 3 years in the context of FMLA. All records regarding notices and leave periods should be retained under this record retention schedule, and it really highlights the need to keep the records. So just make sure you're doing those notices and then that you're retaining them. And obviously to the extent that they have HIPAA protected information, that you're doing that in accordance with your HIPAA policies. So really quick, I know we're a little late, but I'm going to give you quick 5 takeaways, Frank's top 5. Just a summary a little bit, and something I want you to take away and think about is the top 5 things that if you can go back, look at your policies, consider your practice options and what you do to make sure that you're considering these issues. Number 5, notice the notice rules. So it's easy to feel like those are just little bothersome requirements, but they're so important. It's important for creating your record. It's important so you don't get monetary penalties. And it's important at the end of the day because it really sets up the process for you. So if something happens at the end of that road, that highway to you know where, then you have this notice provision to go back to that sets up what the requirements were each step of the way. So remember, for notice, you've got the general notice, which is the poster you're going to get off the DOL website. You've got the individual employee notice. If you have eligible employees, do it by the handbook or do it through any other kind of electronic means, through direct notice on hiring or otherwise. You've got the eligibility and rights and responsibility notice that has to be provided within how long? 5 days, within 5 business days of knowing that they need leave or when they request the leave. And then you've got the designation notice, also a DOL form. You have to provide that again within 5 days of having all of the information necessary to make your determination of whether they're granted the FMLA leave or not. And again, I say use the DOL forms. It's easy and you know you're covered. Number 4, the certification process. Use it. It's a great tool because if you don't get certifications and then you start getting into this no man's land of the employee not coming back, you don't have a lot to work with. So be consistent. Don't be willy-nilly. Don't just say, oh, because I think Frank doesn't look sick, I'm going to make Frank get certified. Have a process for how you apply it. Be uniform. Document, document, document. Use those DOL forms for the certifications that I mentioned, because they have a certification form for serious medical condition of employee, service medical condition for the spouses, and also for military. And then calendar the dates. Make sure you calendar. 5 business days goes fast. If you're out on vacation for a week, if you don't have someone looking over your shoulder and covering for you, these types of calendaring dates could be missed. And I've got a question.
So we haven't given out the employee notice at orientation. Do we need to now go back and give all our employees that notice retroactively?
I would, if it's not in your handbook. I mean, you may have a handbook provision that covers the notice because it's pretty basic in terms of FMLA being available to them. So if you have a question about that, I'd be happy to look at your handbook policy. It's likely that it covers it. But if not, then it's really easy to do just a big blast across your workforce to provide them with the notice electronically or otherwise on these basic notice points.
Can you give a quick, easy recommendation on how to decide whether, based on the completed doctor's certification, the leave does actually qualify for FMLA?
Well, quick and easy. Not 2 words I'd use to describe FMLA. Generally, what I would say is this, and this is what I say when clients ask me about what's a disability. Usually I will say, just consider that it is a serious medical condition. Just consider it as a disability, because the law has become so liberal in how it interprets those issues. If the doctor is saying this person has a serious medical condition and needs to be out of work for this period of time, I think by and large you need to accept that. Now, you do have the right for a second opinion. So if for some reason you believe that that doctor is not to be believed, you know, there's a lot of, we call them pill mills, you know, those types of clinics that you believe, oh, you know, anybody could walk in and get this note, and I'm not sure that that has the appropriate validity. You can get the second opinion, but beyond doing that, which does cost the county money, so you probably don't have the budget to do that, except in extreme circumstances, I would say you tend to need to accept what the doctor's saying, because otherwise it's very difficult not to discriminate against the employee or not to violate HIPAA by trying to go behind the doctor's notice to ask for additional details. But remember, you do have the right to ask them to provide additional information and additional certification. So that could be a first step if you're unsure. Otherwise, I think you assume that it is appropriate. Now, of course, if it's not, you know, a serious medical condition for the employee, I think you're typically going to assume is appropriate if you get it from the doctor. If it's for the caring of, you know, a cousin, well, then you need to look at that and go, wait a minute, that cousin may be sick, but that doesn't work. That doesn't fit within eligibility. So it doesn't mean you always assume every qualifying reason is legitimate. But I think your question was mostly as to serious medical condition of the employee. If you've got a doctor's note on that point, I think it's really hard to go around that. Going on Frank's top 5 takeaways, if I can get my clicker back, Dan. All right. Number 3, Frank and Francine, consider spouses and combined leave opportunities. This comes up more than you realize, and it may not even cross your mind that they're coming in at different times and stacking up leave. So be mindful of that, and consider, importantly, whether you have a spousal combined leave policy in your handbook, because that could be a really useful thing to add so that there's no question about how you'll treat them in these situations. Top 2 reason and takeaway for today is concurrent leaves. A good reason to recheck your policy. If you don't have concurrent leaves provided for under your employee handbook, I would really suggest you consider doing that, because when you allow an employee to stack leave, it's a hardship on the employer. It can extend out the opportunity for the employee to have additional things occur that may be a burden upon your health insurance, and those types of things. There are additional liabilities. So I would suggest that you look at that. I think that's a really important concept coming out of this. If you don't have a no stacking policy, that you look at getting one. And last top 1 takeaway of the day is our farewell Frank concept. And again, this is the number 1 question I always get, considering whether extended leaves, failure to respond, all of those types of what happens at the end of that highway when it's not going well. That is when you really need to make sure you keep in mind the Americans with Disabilities Act. because you don't want to just shut off FMLA at 12 weeks without doing a thoughtful consideration of whether ADA applies. The employee may not know to come to you and say, I need an accommodation, but you need to be mindful of how that could be a discriminating factor if you don't consider whether ADA accommodation is appropriate at the end of this process. And with that, that's everything A to Z. Y'all did a great job on your fact and fiction questions, and I appreciate all the wonderful questions. If you have any more, I'll be happy to take them. Anyone else that needs to jump off the call at this point, please know that we're going to follow up with you. We'll provide you this PowerPoint so you'll have it. It has the roadmap that I think is useful. It has the flow chart on certifications that I think can be a nice handy reference tool for you. And we'll provide the forms that I've talked about as well with the checklist. So look out for those materials coming to you over the next few days. And otherwise, if you have any more questions, I'm happy to share a little more time with you.
Very good, very good. One question, I'm not sure I get this. Do you have a P&P our county can use out P&P book?
P&P.
Do you have a P&P?
Practice and policies, maybe?
Yeah, maybe.
Well, if the question is, do I have like a standard FMLA policy? I would be happy to share that. I will say that depending on how your county works and how you do leave requests and different things, there may be some fact-based things that would not necessarily be what you would want to implement or work within other aspects of your policies, but I can certainly provide that. We can include that.
And we'll put a couple sample things. So.
Yeah, we can put some sample.
Great audience, great questions. Thank you so very much. Angela, thank you to all the participants. You did a great job. Again, we'll be sending out the recording, the PowerPoint presentation, policies and other documentation later, but thank you so much and we'll see you next time.
Thank you. Have a great day.